Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, any views and opinions expressed in this podcast are those of the podcast creator alone and do not reflect or represent the views, positions, or policies of any organization, institution, or entity, past, present, or future, with which the creator is or may be affiliated.
Welcome back to the Deep Dive. Today, we are strapping in for, well, a really specific look into pharmaceutical patent law. It's a high-stakes battle over a cancer drug, bendamustine, which you might know as Belrapzo. Yeah, the stakes were definitely high, but what's maybe even more interesting is the legal twist that decided it all. We're talking about this almost paradoxical situation where patent holders can lose out because they disclosed too much information but didn't claim it specifically enough.
That's right. It highlights this tension perfectly. We're looking at Eagle Pharmaceuticals Inc. v. Slayback Pharma LLC. And our goal today is really to unpack how one seemingly small chemical substitution managed to completely derail a major infringement lawsuit.
And how this Federal Circuit decision really hammered home a tough lesson for anyone involved in innovation or, drafting patents.
Exactly. We'll break down the judgment step by step.
Okay, let's start with the basics then. Laying out the facts. Who are the key players here?
Sure. So the appellant, the plaintiff, was Eagle Pharmaceuticals Inc. The appellee, the defendant, was Slayback Pharma LLC. Slayback was the one trying to get approval for a generic version of Eagle's drug.
Got it. And the judgment itself?
This decision came from the United States Court of Appeals for the Federal Circuit. The date was May 8, 2020. The judges on the panel were O'Malley, Reyna, and Chen. Judge Reyna actually wrote the opinion.
Okay. And the case number, just for anyone wanting to look it up.
It's case number 2019-1924. It was an appeal that came up from the District Court of Delaware. And the lead lawyers were Daniel Brown for Eagle and Constance Huttner for Slayback.
All right. Now, the science bit. Eagle sued Slayback over 4 patents for Belrapzo. What was the specific formulation Eagle patented?
The key thing was the liquid part, the pharmaceutically acceptable fluid. Eagle's patents required a specific mixture, polyethylene glycol, or PEG, and propylene glycol, PG, plus they needed an antioxidant in there too.
Okay, PEG and PG. So what did Slayback do?
Slayback's generic version was, well, almost identical. They admitted it infringed pretty much all the patent limitations except for that fluid part.
So the crucial difference. What did they use instead of the PG?
They used ethanol.
Ethanol, okay. And Eagle's reaction?
Eagle sued, arguing that ethanol was basically an equivalent substitute for PG. They tried to use the doctrine of equivalence to say Slayback was still infringing.
Makes sense. That doctrine exists to stop minor tweaks from avoiding infringement. But Slayback had a counter strategy.
Oh, yeah. A very aggressive one. They didn't even wait for discovery or anything like that. They immediately filed a motion for judgment of non-infringement right on the pleadings. That's Rule 12C.
Wow, straight out of the gate. On what grounds?
They invoked the disclosure dedication doctrine. Slayback argued that Eagle, in its own patent documents, had effectively disclosed ethanol as an alternative fluid, and by not claiming it, had dedicated it to the public.
So Eagle basically gave away the alternative Slayback was using.
That was Slayback's argument. And the district court actually agreed with them. They granted Slayback's motion back on May 9, 2019. That's why Eagle ended up appealing to the Federal Circuit.
Okay, so that sets the stage perfectly for the Federal Circuit's review. What were the core legal questions they had to grapple with?
There are really 2 main things. First, the substance. Did the disclosure dedication doctrine actually apply on the merits? Had Eagle really dedicated ethanol to the public just by mentioning it?
And the second?
The second was procedural. Was it okay for the district court to decide this whole thing so early just based on the documents using that Rule 12C motion? Or should it have gone further, maybe to discovery or trial?
Right. This really gets to the heart of that tension we mentioned. You've got the doctrine of equivalence, the DOE, which helps patent holders catch those slight variations.
It's their safety net, in a way. Prevents competitors making, tiny insignificant changes just to avoid literal infringement.
But then you have this disclosure dedication doctrine acting as the counterbalance.
Exactly. It comes from a really important case, Johnson & Johnson. And it basically says, look, if you write something down in your patent's description as an alternative, but you don't actually include it in your claims, the part that defines your legal monopoly, then you've given it away. It's dedicated to the public.
It reinforces the idea that the claims are king.
Precisely. It's all about the claims. What you claim is what you protect.
But hang on. Isn't it standard practice to mention alternatives in a patent? How could just, listing ethanol sink Eagle's entire case? That seems harsh.
Well, that was pretty much Eagle's argument on appeal. They tried really hard to argue that the disclosure wasn't as broad as Slayback claimed.
How did they frame that?
They said, look, ethanol wasn't disclosed as an alternative for the specific claimed. Mix the one with PEG and PG and the antioxidant. They argued the patent only mentioned ethanol in the context of a different, completely unclaimed formulation, one involving chloride salts.
So they tried to build a wall around that disclosure, saying it only applied over there in that unclaimed section.
Yes. They even brought in an expert, a Dr. Amiji, who testified that someone skilled in the field, reading the patent, would see these as totally separate solvent systems, working differently.
So the argument was essentially, yes, ethanol's in the document, but context matters. We only meant it for that specific unclaimed scenario with chloride salts, not for the main formulation Slayback is copying.
That was the crux of it. But Slayback's counter was devastatingly simple.
What was their line?
They just pointed back to the patent text itself. They argue the specification repeatedly and unambiguously calls ethanol out as a pharmaceutically acceptable fluid. They highlighted lines like, preferred pharmaceutically acceptable fluids include PG, PEG, or ethanol. No qualifications mentioned there.
No mention of chloride salts in that sentence.
None.
Yeah.
Slayback argued this broad statement, without any strings attached in those instances, was enough. It dedicated ethanol as a perfectly acceptable fluid for the purpose stated in the relevant claim limitation, regardless of other contexts elsewhere in the patent.
Okay, so the battle lines were drawn. How did the Federal Circuit rule on this?
They sided with Slayback. They affirmed the district court's judgment of non-infringement. Eagle lost.
Right. So now let's really dig into the why. What was the Federal Circuit's reasoning? How did they dismantle Eagle's arguments?
Okay, they hit several key points. First, they flat out rejected Eagle's attempt to isolate the disclosure by saying it was only in an alternative embodiment.
The chloride salt argument?
Right. Citing that Johnson case again, the court said the dedication doctrine doesn't care if the disclosed alternative, ethanol, appears in an embodiment that's different from the claimed one, the PG-PEG one. What matters is whether it was disclosed as an alternative to the specific claim limitation at issue.
And that limitation was?
Just the broad term, pharmaceutically acceptable fluid. That was the actual phrase in the claim they were fighting over.
Okay, so because the patent explicitly listed ethanol as a pharmaceutically acceptable fluid, it didn't matter if it was also mentioned elsewhere in a different context.
Exactly. That leads to the second major point in their reasoning. The court looked closely at that claim limitation, pharmaceutically acceptable fluid. They found the patent specification repeatedly identified ethanol as fulfilling that exact broad purpose, often without any qualification linking it only to chloride salts or anything else.
I see. So the breadth of the claim limitation itself was a problem for Eagle.
It was, and this is where they distinguished Eagle's case from another important precedent, Pfizer v. Teva. Eagle had tried to use Pfizer to support its case.
How is Pfizer different? Why didn't it save Eagle?
In Pfizer, the situation was different. The patent claim there required an ingredient to perform a very specific function, something like inhibiting hydrolysis. The alternative ingredient that was disclosed in the Pfizer patent's text was never actually described as performing that specific function.
So the alternative didn't meet the functional requirement of the claim itself.
Correct. Because it wasn't disclosed as serving that specific claimed purpose, it wasn't considered dedicated. But here, in the Eagle case, the claim limitation was just pharmaceutically acceptable fluid. There was no extra specific function tied to the solvent choice in the claim itself.
And the patent did explicitly say ethanol was a pharmaceutically acceptable fluid.
Repeatedly. So the court said, unlike Pfizer, ethanol clearly served the stated broad purpose of the claim limitation. The dedication doctrine applied.
That distinction is crucial. It highlights the importance of linking function to structure in claims if you want to avoid this trap.
Absolutely. If Eagle's claim had required, say, a fluid that enhances antioxidant stability, and ethanol was only ever mentioned as a general solvent, maybe the outcome changes, but they just claimed acceptable fluid.
Okay, what about the procedural point? Eagle brought in an expert, Dr. Amiji, saying a skilled person wouldn't see ethanol as interchangeable here. Why did the court basically ignore that expert declaration?
Yeah, this is interesting. The Federal Circuit found no fault with the district court ignoring Dr. Amiji's input. They pointed out a couple of things. First, deciding whether to consider outside evidence on a Rule 12c motion is up to the court's discretion.
Okay.
Second, and more importantly, they stressed that applying the disclosure dedication doctrine is ultimately a question of law, not a question of fact.
Meaning it's about interpreting the legal meaning of the patent document itself, not about gathering external opinions on what a skilled person might think.
Pretty much.
Yeah.
The district court had called the declaration an attempt to manufacture a factual dispute, where none really existed based on the patent's own words. The Federal Circuit agreed, saying the patent documents provided sufficient context to decide the legal issue.
So they felt the patent was clear enough on its face.
Yes. They concluded that the only reasonable inference someone could draw just from reading the patent was that ethanol was indeed disclosed as an alternative pharmaceutically acceptable fluid. No need for expert testimony or a trial to figure that out. The document spoke for itself.
So, to recap the legal anchors here, Johnson & Johnson established the core dedication rule, and Pfizer v. Teva helped clarify how that rule applies depending on whether the claim includes specific functional requirements.
Those were the key precedents driving the analysis. And it's worth noting the sources don't mention any dissenting or concurring opinions from the Federal Circuit judges.
Suggesting a fairly unified view on how these principles applied here.
It seems so. A clean affirmation based on established patent law.
Okay, stepping back then. What's the broader significance of this ruling? What should patent folks and innovators take away from Eagle v. Slayback?
Well, it's a really stark reminder about the risks of, let's call it, over-disclosure in the specification if you don't back it up with corresponding claims. You can't just list alternatives broadly and then hope to recapture them later using the doctrine of equivalence if a competitor picks one.
Even if you intended that disclosure to be limited contextually?
Exactly. The court reads the specification as a whole from the perspective of someone skilled in the art. If you state clearly that X can serve the same broad function as your claimed element Y, without clear qualification tied to the claim, you risk dedicating X. You can't hide it in an unclaimed embodiment and expect it to be ignored for dedication purposes.
So if you had to distill this whole case down to one single crucial takeaway message for our listeners, the absolute key point.
Be meticulous.
Yeah.
Excruciatingly precise in your claims. If you mention an alternative ingredient, process, or method in your patent's description, especially if you identify it as serving the same general purpose as something you are claiming, you absolutely must claim that alternative explicitly if you want to protect it.
Otherwise,
Otherwise, you've dedicated it to the public. It's fair game for competitors like Slayback. They can use it freely, and your infringement claim based on equivalence will likely fail right out of the gate, just like Eagle's did. Precision in claiming trumps sheer volume of disclosure every time.
It really is striking how a massive infringement lawsuit got shut down so early, purely based on the words Eagle themselves wrote in their patent. A win on the pleadings, not after years of litigation.
It perfectly illustrates that fundamental patent law bargain, doesn't it?
Yeah.
You get a monopoly, but in return, you have to clearly teach the public about your invention through disclosure.
Yeah.
And that monopoly, it only extends as far as your claims clearly define it. Everything else disclosed is essentially part of the payment back to the public.
Okay, a final thought then for everyone listening to chew on. The Federal Circuit found the patent's disclosure so unambiguous that they wouldn't even consider expert testimony trying to argue about interpretation. What does that say about the sheer, almost absolute power of the written word, or maybe the failure to use the right qualifying words in a patent document? Something to think about.
Thanks for tuning in to the full episode. If there's any topic or case law you'd like us to cover next, share your suggestion in the comments on our latest video. And if you found value in the podcast, don't forget to like, subscribe, and hit the bell icon to stay updated.